All right, is everyone ready?
Yes, ma'am.
All right, so let's begin with Brianna Ross on the,
North Broward?
She's in North Broward, Your Honor, and she was interested in resolving this matter this afternoon.
okay?
She's on her way. She's right here.
All right. All right, so Ms. Ross is before the court on a resisting without violence, and I find probable cause. And Ms. Ross, you want to resolve your case this afternoon?
Yes.
Okay. State you have an offer?
Yes, Judge, the offer be withhold court costs.
Is that what you'd like to do, Ms. Ross? No conviction on your
No.
record and pay court costs?
I don't want it on my record.
It won't be a conviction.
Okay.
All right, so do you understand that, and do you wish to accept that offer?
Yes.
All right, please raise your right hand. Do you swear or affirm to tell the truth?
Yes.
Okay, you can put your hand down. And do you need any more time to speak with your attorney?
That one.
I spoke to him.
Okay. Is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No.
And you understand that you have the right to go to trial, but by taking a plea today, you are giving up that right?
Yes.
And have you ever been treated for mental or emotional illness?
No.
And do you understand, ma'am, that if you are not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
Yes.
Okay, what plea do you wish to enter? Guilty or no contest?
No contest.
All right, I accept your no contest plea. I find that it's freely and voluntarily given. Your sentences withhold adjudication and court costs. Good luck, ma'am.
Thank you.
Okay, Kyle Lewis.
Bonded.
Mr. Lewis bonded.
They renamed your city.
And Andrew Ritchie.
He is here at Main Judge and he is approaching.
All right, Mr. Ritchie, you are before the court, charge one, burglary, unoccupied dwelling unarmed. Number two is grand theft. Number three is burglary, unoccupied dwelling unarmed. Number four is grand theft. Number five is burglary. Number six is grand theft, and number seven is another burglary. Okay? And I find probable cause as to all those counts.
Your Honor, the state would be requesting $7,500 bonds on 1, 3, and 5, $2,500 bond on 7, no victim contact, no return, noting that this is more than just a mere isolated incident. There's allegations that he broke into 3 separate homes, then broke into someone's car. He's 18. As a juvenile in 2017, he went through a diversion program for burglary of a conveyance, possession of burglary tools, trespass, and resisting without violence.
Fortunately, Mr. Ritchie's not going to be able to afford to post a monetary bond, nor his family. Now, he's 18. He's been here his whole life. He was scheduled to start school today, actually, at Pepper High School. He's going to be a senior. He's not getting off on the right foot right now by missing school. He has a 2.0 GPA. He says he's a couple credits behind, so if he puts a lot of effort, he can make up for it and hopefully graduate on time. Now, he lives in Lauderhill with his grandmother and 2 younger sisters. Also, his uncle and aunt live in the same household as Mr. Ritchie. From what he advised me, he doesn't believe his family can afford very much or anything at all. So we are asking for the court to consider placing him on level 2 pretrial with a monitor.
All his priors are juvenile, Mr. Linder?
Yes, it looks like he just turned 18 March of this year,
And when was the last juvenile?
2017.
And what was that? What was the charge on that?
Burglary, conveyance, possession of burglary tools, trespass.
All right, that's the first day of school. I am going to impose a $2,000 bond on 1, 3, and 5, 1, 3, and 5. And 7. Okay,
Yes, Judge.
all right.
And Your Honor, no return, no
And
contact.
no return to this location, these locations.
Thank you.
Mr. Ritchie, you gotta think about your future, sir. All right, Kelvin Jordan.
Good luck, sir. Mr. Jordan is here at main judge approaching. Mr. Jordan, come on up, please.
All right, Mr. Jordan is before the court. Charge 1 is battery on an officer or firefighter. Number 2 is resisting officer without violence. Number 3 is resisting officer with violence. Number 4 is felony violation of probation with a no bond hold. Number 5 is a traffic infraction not for magistrate. Number 6 is a violation of felony probation. And that has a bond attached to it. $5,000. Judge Rothschild imposed a $5,000 bond on that BOP. So, yes?
Well, I think it's actually gonna be no bond on the 94806, Your Honor. Judge Rothschild issued the $5,000 bond when he didn't report to probation obviously before these new offenses were allegedly committed. When he got arrested for these new offenses, the arresting officer charged him with a violation of probation under 94806.
All right, and he has court tomorrow with his division judge. So I find probable cause.
State would request a $1,000 bond on count 1, Your Honor, and a $500 bond on 3.
And Judge, considering he has no bond holds, nothing to add from the defense except for a photo order, Judge.
All right, I'll sign that, 1,001, 500 on 3, and he has court well, I don't know when he has court. This says 8:14 on my notes.
Yeah.
So he's
Should-
probably
I would
going to
imagine
court
either tomorrow or the next day
Tomorrow or
before
the
Judge
next day.
Coleman.
Okay. All right. All right, Guillermo Salazar.
Mr. Salazar is approaching, Judge, and he declined the service of public defender. He said he is going to be hiring his own attorney.
Okay. All right, Mr. Salazar, you're before the court. For charge 1 is possession of THC, and number 2 is possession of cannabis 20 grams or less. And I find probable cause. Does Mr. Salazar have any priors?
I don't see any history, Judge.
Okay. All right, so Mr. Salazar, you have $1,000 bond. Are you able to afford that?
Yeah.
Okay, all right, good luck, sir.
Okay.
All right, on the misdemeanor hearing docket, Joanne Balkunas.
She is in
All right.
All right, and she would like to resolve this matter.
Okay.
She's on probation, and that's, she resolved her other outstanding charges.
All right, so Ms. Balkunas, you wish to resolve this, it's a municipal ordinance matter, it looks like.
Yes, ma'am.
All right, you'll be sentenced to time served if you wish to resolve it.
Yes, ma'am.
All right, please raise your right hand. Do you swear or affirm to tell the truth?
Yes, ma'am.
Okay, you can put your hand down. And ma'am, do you understand everything that we've discussed here today?
I do, Your Honor.
Is anyone forcing you to resolve your case?
No, ma'am.
And are you under the influence of any drugs or alcohol?
No, ma'am.
Do you need any more time to speak with your attorney?
No, ma'am.
Have you ever been treated for mental or emotional illness?
Yes.
And is there anything about that today would prevent you from making a decision?
No, ma'am.
And you understand you have the right to go to trial, but by taking a plea today, you are giving up that right?
Yes, Your Honor.
And do you understand, ma'am, that if you are not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
Yes, ma'am.
All right, what plea do you wish to enter?
No content?
All right, I accept your no contest plea. I find that it's freely and voluntarily given. Your sentence is adjudication and time served, okay?
Thank you, ma'am.
You're welcome.
Good luck.
Jeffrey Prescott.
Conti, Your Honor.
All right, so Mr. Prescott was arrested on July 28th, though this is a second look at his bond. How much bond does he have?
I'm not sure, Your Honor. I believe he also had a felony matter that he's since resolved.
Okay,
If he wishes to resolve this, the offer would be an adjudication time served. Court order, no return to 4185 Davy Road in Davie.
all right. Mr. Prescott, do you wish to resolve this trespassing charge today?
Yes, ma'am.
All right, please raise your right hand. Do you swear or affirm to tell the truth?
Yes, I do.
Okay, you can put your hand down. And do you need any more time to speak with your attorney?
No, ma'am.
Are you under the influence of drugs or alcohol?
Absolutely not.
Is anyone forcing you to resolve your case?
No, ma'am.
And you understand that you do have the right to go to trial, but by taking a plea today, you are giving up that right?
I do.
Have you ever been treated for mental or emotional illness?
No, ma'am.
And, sir, do you understand that if you are not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
Yes.
Okay, what plea do you wish to enter?
No contest.
I accept your no contest plea. I find that it's freely and voluntarily given. Your sentence is adjudication, time served, and also, sir, no return to that location, as you heard before, okay?
Yes, ma'am.
All right. Anthony Peterson,
Mr. Peterson is in North Broward. He would like to resolve this matter today, Judge.
all right. So Mr. Peterson has been in custody now 4 days. This is a resisting without violence. It's a state charge.
Yes. And, Your Honor, I'll make Mr. Peterson offer, but honestly, and I don't know if it's substance abuse issues or if there's other issues going on or both. I don't think Mr. Peterson can expect a time-served offer again out of this division, at least not from the state. He's becoming a nuisance in the city of Coral Springs. This incident occurred, one moment, at a, he was trespassed at a Benihana's. He refused to leave. Then he ran from law enforcement. This was after he had just been trespassed at a different restaurant a couple hours earlier. Last year, he was trespassed and kicked out of, what was that? Let's see what restaurant that was. An Applebee's, where multiple patrons were being disturbed by his behavior. This is all going on in the city of Coral Springs, and so he's had trespasses in Coral Springs, multiple trespasses, resisting without violence. So the office adjudication time served, but it's probably the last one.
All right, Mr. Peterson, have you ever been treated for mental or emotional illness?
No, ma'am.
All right. Okay, so you understand what has been said here today?
That this would be the last, yes.
Well, you understand the offer that has been extended to you to resolve the case?
Yes, with the time served, yes, ma'am.
All right. So please raise your right hand. Do you swear or affirm to tell the truth?
Yes, ma'am.
Okay, you can put your hand down. And Mr. Peterson, is anyone forcing you to resolve your case today?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
And you understand that you have the right to go to trial, but by taking a plea today, you are giving up that right?
Yes, ma'am.
And, do you understand that if you're not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
Yes, ma'am.
All right. Then, what plea do you wish to enter?
I'll do the time served.
No, you've got to enter either a guilty plea or a no contest plea.
No guilty plea.
No, the options are guilty or no contest.
No contest, ma'am.
All right, so I accept your no contest plea, and I find that it's freely and voluntarily given, and your sentence is adjudication and time served. And sir, I'm ordering you not to return to the Benihana's restaurant in Coral Springs. Do you understand that, sir?
Yes, ma'am.
All right, and, no return means no return. So.
Yes, ma'am.
So if I were you, I would even, if I don't know what kind of area it's in, I would just stay away from that area. How about that?
Yes, ma'am.
All right, good luck.
Thank you, ma'am.
All right, and then on our felony docket, we have Desiree Nafotny.
She's in Conte, Judge.
Do we have,
Oh, I'm sorry. My mistake.
okay. All right, this, my notes say that she was arrested on June 30th, so this is a 30-day motion.
She was originally arrested June 30th. I'm going to ask that this matter be reset for Monday, Your Honor.
Okay,
Ms. Novotny was first arrested on June 30th. She bonded out or was released on July 2nd, thereby
Okay.
essentially having 2 days in custody.
okay,
She was then arrested on July 18th on a new offense. Her bond was, or whatever release conditions were revoked on this case. So she's been in custody since July 18th, thereby being another 27 days. She's been in custody a total of 29 days. Since the 33rd day would fall on this Sunday, I'm asking that the matter be reset for Monday.
all right, I'll grant that. So we'll see you on Monday, Ms. Novotny. Okay?
Thank you.
All right, Stanley Rivers
He's downtown, Judge.
is in
Well,
court.
if you want to waive his, I don't know if you want to waive his appearance.
Yeah, well, if you're going to give me some good news, I
Well,
will.
it looks like this is one of those arrested and then is a
I
rearrest.
did, I did the math, Your Honor.
Okay.
He's been in a total of, he was arrested July 1st. He got out July 8th, so he was in for 7 days. Then rearrested on the 14th, so from the 15th to today is 30 days. He's been in a total of 37 days.
Okay,
Information has not been filed. He's entitled to release.
all right. So I will sign the order granting the ROR. on
And I'll waive his
Mr.
presence.
Rivers. Okay. And then DeMarcus Matthews.
Conte, I believe, Judge.
Your Honor, this is a motion to release for trafficking in fentanyl. Today is the 33rd day. I spoke with Assistant State Attorney Jonathan Goodman yesterday. We have not received the lab results yet, and the state is asking for an good cause extension to the 40th day, relying upon Davis v. State. Your Honor, just some things I want to bring to the court's attention. This delay is not caused by inaction by the state. It is no fault of the state, Your Honor. I've actually spoken with Denise Nooner this afternoon, who is the the supervising assistant state attorney for our drug trafficking unit, and Yanae Gatorno, who is I believe, the head forensic chemist at the lab, just to get some more information. There's a misconception, Your Honor, a couple misconceptions, that some people believe that, the members of the lab are just sitting around, letting work go by. Your Honor, I can tell you, the lab is fully staffed. The instruments are running 24 hours a day. But there are things that most people are not aware of that goes on in testing these drugs that causes delay, especially in trafficking matters, Your Honor. For instance, there's a specific protocol, especially with fentanyl, just because of the dangerousness of fentanyl, that extra precautions have to be taken into the testing of them. This causes delay in time, Your Honor. Additionally, for instance, where there was once 34 substances that could be charged with trafficking, with the addition of new compounds and compounds that haven't even been formally discovered yet, there's 350 trafficking substances. And every test that's run has to be checked for all of these substances. There are compounds where there is no standard procedure, where the chemists have to meet, then they have to find another lab to send the materials out to have those tested, Your Honor. The court should be aware, in trafficking matters, there's a sampling plan. And what I mean by that is, for instance, if let's say there's 100 pills in a case, under the sampling plan, 40 of the pills minimum have to be tested. Each pill is a process of 8 to 10 hours. Another misconception is that, Your Honor, the lab just tests for identification purposes, for filing purposes, and then it's done. But that's not the case either. There's also, specifically for trafficking cases, trial testing, additional work, continuous work that has to be done even after the initial lab work, Your Honor. And the reason I bring this all up is this is all work that is continuously going on all the drug cases by the drug lab. And it isn't just any one particular case. It's everything that's going on with all these, and that is why there is such a delay, Your Honor. The court, you're here every day during the week, Your Honor. Also, I would also want to advise that the analysts are only able to work between 40 to 60 items a month. And when I say items, I mean drugs. So let's say someone's charged with 2 counts of possession of cocaine with intent to sell. The lab, each chemist can only work 20 cases of those 2 charges, between 20 and 30 a month, because that would be the 40 to 60 items that they have the time to work on, Your Honor. As you're quite familiar, how many drug cases we get in this county every single day.
All right.
Well, we've had this argument or discussion where reasonable people disagree reasonably many, many times. It is not Mr. Matthews' fault that the lab is incapable of performing their duties. The statute clearly says that Mr. Matthews is entitled to be released on his own recognizance if the charge is not filed within a certain period of time, and the charge has not been filed within that time frame. And I appreciate what Mr. Linder's saying, but that is not to blame Mr. Matthews for this. And we see this all the time. We have people being released from jail on their own recognizance every day because the lab fails to get the drugs tested in time. And the tragedy of it really is that many people are released not to a program and not to any type of counseling or probation. They're just basically tossed out the door on their own. And that doesn't bode well for their chances of straightening out and not becoming a recidivist. So the lab is just a miserable failure. I mean, I don't know how else to phrase it. And I would object to the state. This has been going on for 7 or 8 years now, where we have lab technicians doing more drugs than they're testing.
Objection, Your Honor.
Mr. Reedy,
Well, I mean, that's the situation, Judge, and quite frankly, I find it very, very frustrating.
I don't know that, I don't even know the truth to all of that. So let's just stick to the facts of the,
Well, the facts of this case, Judge, is we're talking about one white powder substance wrapped in cellophane that weighed 5.3 grams, approximately, with packaging. So I don't understand how you can't test It's not like Mr. Matthews was caught with, a pound of drugs or a kilo of drugs that need to be tested. It's 5.3 grams or less. And it might even be less than 4 grams with packaging, which would mean it's not even trafficking. But because the lab is incapable of getting their job done, we don't even know that. So I think Mr. Matthews should be entitled to the benefit here, Judge, and I would ask the court to grant the defense motion to release him on his own recognizance at this time.
well, I'm going to deny that at this time, because our appellate courts have allowed, based on these reasonings, to grant the state the extended time. So I'm gonna grant the extended time. I'm gonna ask Mr. Linder to draft that order and to specify the date on.
Wait,
Your
what
Honor-
date are we talking about, Mr.
And
Linder?
Your Honor, and I can tell, it's in the order, the 40th day is August 21st. Today's the 33rd day, August 21st is the 40th day. I've already put in the order that should the state not file information by 5 PM, he is to be automatically released. There's no need for another hearing, Your Honor.
Right, okay. All right. All right, Christopher Brown,
Mr. Brown is in Conti, Judge.
okay. All right, good afternoon, Mr. Brown. Mr. Brown was arrested on July 12th. So, has the information been filed? Sorry, Gus, go ahead.
I got it. Your Honor, the state has not filed an information, so Mr. Brown's entitled to release. It appears at this time that the charge is going to be declined, so Mr. Brown should probably keep in touch with his public defender to keep up to
Alright.
date with what happens on the
So,
case.
Mr. Brown, I will sign the order granting your release.
Yes,
And-
ma'am.
And as you heard, just double check with your attorneys after you've been released, okay?
Thank you, Your Honor.
All right, Marvin Jean,
Conti as well, I think, Judge.
Yes, ma'am. Conti.
all right, Mr. Jean was also arrested on July 12th.
Yes, Judge, and the state has not filed an information. Mr. Jean is entitled to an ROR at this time.
All right, so Mr. Jean, is that you, sir?
Yes, ma'am.
Why don't you approach the podium, Mr. Jean?
Okay, you can stand up, it's okay. All right, so the state has not formally filed the charges, so you are entitled to an ROR, so I'll sign the order releasing you. Okay? You need to make sure you stay in touch with your attorney so that you know if you have to come back to court, okay?
All right, thank you.
All right, and then Keenan Joseph,
I believe he's in Conti also.
okay? And Mr. Joseph also was arrested on July 12th.
Yes, Your Honor, information was filed today for burglary of a dwelling.
All right. All right, so, Mr. Joseph, the state has formally filed the information in your case, and so you should be going before, your division judge for arraignment, shortly, so at this time, I'm going to deny the ROR, okay? All right, Sabrina Moore,
Medical reset.
all right, and Alejandro Murillo,
Judge, I've been advised he's a medical reset.
okay? And Lawrence Hannah,
I believe he bonded.
And, bonded.
okay?
Mr. Spargo, come on up.
All right,
Fargo's the only one left.
Bobby Tucker,
I believe he bonded.
Did,
Mr. Tucker bonded.
yes.
Correct.
Calvin Jones,
Bonded also.
bonded, okay. And John Spargo,
Main jail.
He is here, main judge. He initially declined the service of public defender. Again, today I asked him again, he's declining again, Judge, but I believe he has a request to the court.
okay. Yes, sir.
ROR.
That's, oh, okay. I understand that request. What was the, what is, Mr. Spargo's, criminal history?
One moment, Judge. As far as Broward, Michelle, do you have any notes? I know he had a trespass from earlier this year. I don't know what his ties are necessarily.
Looks like he's a Pompano Beach address.
Yeah, no, it would appear he's been down here for maybe a couple years. My point is, I don't know if he has priors from outside of Broward.
Oh, I see what you're saying.
So everything out of county, from what you could tell, it was dropped? You tell me.
Then Mr. Spargo had a prescription bottle with 1.8 grams of test substance tested positive for MDMA. Last year.
Just the drug priors?
It's all drug priors.
Yeah, I wouldn't have an objection to pretrial random testing. The only request I'd make, Your Honor, is that it be pending verification.
All right, so Mr. Spargo, do you have a permanent address?
Yes, ma'am.
All right, so, and is there someone there that can confirm the address that that's where you live?
Yes, but I don't have her. I can get in touch with her right now. It's my girlfriend.
Okay,
My girlfriend's apartment.
all right, so I am going to release you to pretrial supervision. They have to verify the address.
Got it.
So it's going to be dependent on, that they are able to confirm the address.
You got it.
And then you will also be subjected to random drug testing,
You got it.
all right? So,
Ma'am.
do you have, is it the address that's on your booking report, or you have another address for your girlfriend?
It's 344 Northwest 7th Street, Pompano Beach.
Okay, well, that's the same address that's on the booking report.
Yes,
So-
ma'am.
And you, what's her name?
Roxanne Buck.
Roxanne Buck? Is that
Yes, ma'am.
B-U-C-K?
Yes, ma'am.
All right, and do you know a phone number for her? Because pretrial is right here, so they can take the information now if you have it.
It's in my phone.
Oh, okay, all right, well, they have the address and they have her name, all right?
So much.
All right, good luck, sir.
Thank you so much, ma'am.
All right.
And Judge, just to let the court be aware.
Yes.
Alejandro Murillo has just been brought, so I'm assuming he's back from medical.
Oh, okay,
He was the gentleman on the felony second look docket.
okay.
It's ready for you, Brian? Sir.
All right, we need to go back to Mr. Murillo, who was arrested August 11th. And,
Judge, Mr. Murillo is here. He was here, I believe, on Monday before you. I believe initially he did decline the service of public defender. He changed his mind. He wants to apply with the public defender's office, being held on a grand theft and possession of oxycodone. He has a $2,000 bond.
okay. And what was his criminal history?
I'm asking pretrial to look that up. The one thing I can tell you about this case, Your Honor, is the state is actually prepared to file charges and is going to be filing these charges. I reviewed the PC. Originally, the PC was done as a not in custody,
Okay,
but I imagine the officer that prepared it came into contact with him and arrested him on the PC. This whole time, the state has had has been investigating the matter, and we've made a filing decision within the
Okay.
past couple days. So now just wait to hear from pretrial.
And Judge, and speaking of Mr. Murillo, the problem seems to be he didn't have any phone numbers memorized. He wasn't arrested with his phone, so he has no one to contact to post this bond. He does advise me that he has an address where he stays at, so he's requesting if the court would consider releasing him on pretrial release.
well,
Sentinel.
okay. And is that the only, all the priors? Okay. It seems like there's a drug problem. These allegations are that he went to visit a friend whose mother was in a wheelchair, and he took $600 and the prescription. for the person.
And, Your Honor, I wouldn't have an objection to the same release conditions that you just set for Mr. Spargo, pretrial, random testing with verification.
So, did you say he has a permanent address?
That's what he just advised me, Judge.
I do.
And what is that address?
9409 South Belfort Circle, Tamarack, Florida, 33321.
All right,
As listed on my license. State ID.
okay. All right, so that's the address that's, on the booking report. So, Mr. Murillo, I will, release you to pretrial supervision with random drug testing and also pending verification of his address. Okay? All right, Mr. Murillo, if you don't, well, they'll have to verify your address, so don't have to worry about that, okay? All right. Do we have anyone else that we missed who's walked in?
No,
All right, thank you, everyone, and I'll see you all tomorrow morning. All right.